Okay, Adab. Welcome to the new term of Decolonial Islamic Spiritualities. I'm Nauman Naqvi. I am an associate professor in the Department of Comparative Humanities here at Habib University. And I'm going to start with some general remarks about this series of ours. In the academic year 2020 to 2021, Habib University's program in Comparative Humanities and the University of Exeter's Institute of Arab and Islamic Studies launched a fortnightly webinar series titled Islam After Colonialism. The series charted the dramatic transformations under the devastating global impact of modern apartheid colonial rule in the nature of Islam in South Asia, across culture, religion, politics, society, and the arts. In the event, the series received tens of thousands of views per webinar across global regions and groups, indicating the extensive public interest in the topic. The decolonial question of alternative pasts and futures was an important part of Islam after colonialism, given that contemporary concepts and imaginations of history, religion, politics, culture, and ethics remain hostage to the modern colonial heritage. This year, our new series, Decolonial Islamic Spiritualities, while remaining in a similar constellation of concerns and perspectives, extends beyond South Asia, as well as focusing in on the spiritual, ethical, and religious resources and potentialities that have been marginalized or obscured through the co-optation of quote-unquote religion by colonialism and its inheritor, nationalism. In an increasingly troubled world, decolonial Islamic spiritualities are essential to the conceptual and existential strength of individuals and communities as they strive towards futures that are reparative rather than destructive. And with me here is my colleague, Dr. Sajjad Rizvi, who is the director of the Institute of Arab and Islamic Studies at the University of Exeter, who will introduce our guests for today. Sajjad.
Sorry, I just lost connection there for a second. I think I'm back now. Yes, so welcome from me as well to this new year and the continuation of our series. It's a pleasure today to introduce Professor Sohaira Siddiqui, who is an associate professor of theology at Georgetown in Doha. She is well known as a specialist in Islamic law and is the author of a recent Cambridge volume on law and politics and the Abbasids, which is a study of the famous Ash'ari theologian Juwayni, but it's much more than just an intellectual biography of him. And she's currently extending her work and into the modern period with a current project which is called Fractured Modernities, Contesting Islamic Law in Colonial India. So that in many ways is directly relevant to perhaps the topic of today and also of our series. So very much looking forward to what you have to say today and present, and looking forward to the conversation. So please, over to you, Sohaira.
Thank you. Assalamu alaikum, everyone. So thank you for the introduction and the invitation from both of you. And this is a series that I've been following with quite a bit of excitement. And so I was quite honored to be asked to speak and kind of provide just some reflections, I think, on this idea of decolonial Islamic spiritualities. I'm going to approach from the perspective of law, and oftentimes law and spirituality people find to be in tension. And so hopefully we'll be able to explore some of that kind of throughout the conversation that we're going to have today. So I'm just going to share my screen to make sure that everybody can kind of follow as I talk. Is that visible to everybody? Okay, so I want to, first of all, just start with kind of reviewing, at least for myself, and then also for the benefit of the audience, something that Nauman already said about kind of how this series is positioned and how I thought about the position of my work then in relationship to the series. And so it's titled, obviously, Decolonial Islamic Spiritualities, and we've been asked to speak about the spiritual, ethical, religious resources and potentialities that have been marginalized or obscured through the co-optation of religion by colonialism, and then, of course, its inheritor of nationalism, with the understanding being that decolonial Islamic spiritualities are essential to the conceptual and existential strength of Muslim individuals and communities as they strive towards, as Nauman said, reparative rather than destructive models of being. Now, as a scholar of classical Islamic law who has become increasingly interested in the transformation of Islamic law through the colonial encounter, when I was first asked to speak about decolonial Islamic spiritualities, I will be quite honest, I was not really sure what my contribution would look like. Despite this, I agreed because I feel conversations like this are quite crucial to have. And even in the other kind of talks that I saw my colleagues participating in, I saw that the engagement that was happening afterwards was so important, both for their own work, but then also just kind of carrying these conversations forward. And so for me, I felt like this was kind of the right venue to have this conversation and think about what Islamic law has to say in this space. As time kind of came closer to the actual date of the event, I was also in the last stages of kind of completing this book that Sajjad mentioned on the transformation of Islamic law in the colonial period. And I was really stuck at the conclusion, which, you know, people will tell you the introduction is hard and writing is hard. The conclusion is often even harder because it's the big so what question, right? You've just spent 3-4 years researching something. Why should anybody care? What are you taking away from this? And I think for me, the reason it was so difficult is I wanted to really step back and think about what was the story of this book telling for South Asian Islam today, and more importantly, for contemporary South Asian Muslims who continue to engage with Islam as a lived reality, which is part of their everyday life, but then also continue to live within oftentimes, you know, the remnants of colonialism. And as a South Asian, this became personal to me in a way that potentially my first project wasn't, as I was invested in that for different reasons, and I'm invested in this for different reasons. And so for both the conclusion of my book and for this talk, the question really became for me, what were the long-term consequences of the transformation of Islamic law during the colonial period on the normative understanding of Islamic law by its practitioners, and more importantly, on the Islamic discursive tradition and the intellectual spaces that it opens up for individuals today. And if I want to say, kind of frame that more specifically within the parameters of this conversation, then it's what were the consequences of the reshaping of Islamic law during the colonial period on the very imaginative space for contemporary Islamic decolonial spiritualities. And I think there is a really intimate connection between how Islamic law was transformed and then what space even exists for conversation today that I kind of want to tease out. Maybe it might be somewhat provocative, and maybe that's a good thing, maybe it's a bad thing, and hopefully our discussion will kind of lead us in interesting directions. But I want to begin by acknowledging that Islamic law was one of those discourses or arenas of inquiry that was not kind of marginalized through the colonial encounter in the same way that other discourses were marginalized. Actually, quite the opposite happened in many instances. So to be a bit more explicit, through the colonial encounter, Islamic law and a very specific colonial interpretation of Islamic law became so central to the religious identity of Muslims that it became the defining feature of Muslim religious identity and public piety. And thus, when we think about Islamic decolonial spiritualities in relation to Islamic law, I would argue that we have really 3 tasks ahead of us. One is to understand how Islamic law was transformed through the colonial counter. The second is to understand how Islamic law functioned in a pre-colonial context. And then once we have a better grasp of these 2, we can turn to the third task, which is to think through what contemporary Islamic legal sovereignty would look like in a way that's responsive to the needs of the community and kind of reparative, right, if we want to use that same language, of the damage done to its epistemological framework and institutions of learning. Now that's a lot to do in 30 minutes, and so that's not all going to happen. So I'm going to focus on what I think is the nature of that transformation based on my recent research, as a way of simply setting up the conversation about what a potential decolonial Islamic legal sovereignty or a discussion around that may look like. And, you know, maybe that's something that will come out more clearly in our conversation towards the end. So I've realized, are my slides working? Is it on the, does it say basic argument at the top now? Sorry, okay, it was stuck on my window. So I found that on Zoom, sometimes it's better just to say what your argument is in the beginning. because, these talks can be long. It's different time zones. People are tired. So I'll just lay out what my argument is, and then you can kind of tune in and out, right, for the next 25 minutes. But the basic argument I want to make is, despite the conflicting epistemological frameworks and notions of authority, both colonial officials and traditional ulama during the colonial period contributed in different but complementary ways to making Islamic law a key site of contestation. And this in turn had a profound effect on the shaping of contemporary Muslim religious identity and intellectual imaginaries. Colonial officials made Islamic law, and then of course, as we know, more specifically, Islamic personal status law, a key site of contestation by identifying and isolating it as the primary site of Islamic religious practice that needed to be regulated and protected by the state. And the ulama, in responding to this colonial encroachment, then were focused on preserving Islamic legal sovereignty, and in doing so, contributed to making Islamic law the primary site of Islamic religious practice, with the key difference being that it was to be, of course, interpreted and safeguarded, in this case, by the ulama, as opposed to obviously the colonial officials and colonial power. And so what ensued was a contestation over Islamic law that was very public, and it made Islamic law the primary public intellectual discourse regarding Islam, not just in the colonial period, but arguably in the post-colonial period as well. And the overall result, I want to argue, has been an expansion of the public intellectual terrain in which Islamic law functions, and a narrowing of the public intellectual terrain in which other Muslim discourses function. And thus, for a flourishing of, what we're calling decolonial Islamic spiritualities, then, as legal scholars, we must think anew about the purpose and scope of Islamic law, both within Muslim communities and within the public sphere. And then also, how can Islamic law as an intellectual discourse meaningfully engage with other decolonial Islamic discourses that scholars are identifying as key to kind of contemporary, contemporary intellectual flourishing or discourse more broadly. So what I want to do to try to kind of streamline and give us enough time for discussion is really kind of divide this talk into 3 parts, which is going to be Blitz history and a few examples here and there. And I realize that, in 30 minutes, I'm trying to do a lot. So I do apologize if I move quickly or I kind of glaze over things, and I'm happy for people to obviously ask questions. But I want to focus on 3 ideas. The first is the creation of what I'm calling is the colonial legal terrain, and I'll explain what that means in a moment. The second is how the ulama then responded to this colonial legal terrain or the colonial encroachment onto Islamic law, and then think about the effect of the creation of this terrain and the response to it when it comes to decolonial Islamic spiritualities, right? And so I think we already know where I'm going, what the end argument is, but this is kind of how I'm going to essentially get us there. So starting with the colonial legal terrain, in his early work, Dalal Asad has argued that the process of colonialism created what he calls a new moral landscape that defined the parameters of both thought and action. And he was animated, but what he saw to be the adoption of European modes of law by Egyptian elites. To this extent, he has stated, "My interest, however, is not in speculating about an old motive resistance, but about new institutional and discursive spaces, themselves not immutably fixed, that make different kinds of knowledge, action, and desire possible." This new discursive space that was constructed by colonial power then became what I'm thinking of as the terrain from which native discourse, especially discourse in conversation with the state, was formulated. Crucially, because this discursive space was constructed by colonial power, Asad refers to those individuals who are operating within this space as conscripts, indicating the manner in which they were compelled to abandon old practices and adopt new ones. Specifically within the realm of law and jural colonization, subjugated individuals adopted Western legal categories not on the basis of persuasive argument, but rather on the basis of constraints put in place for them. Thus, for Asad, in order to understand the true nature of colonial power, it is these constraints that need to be analyzed and evaluated more carefully. In other words, how did colonial power refashion the very terrain from which subjugated populations actually began to articulate their will? So building upon Assad's notion of conscripts and call for an investigation into the full nature of colonial power, David Scott in Conscripts of Modernity argues that what was unique about colonial power and its concomitant rhetoric of reform was that it was not simply worried about the details of discrete behaviors, it was worried about the totality of the social, about an interconnected order of life. And as such, the analytical focus of scholars should be on the form of power that altered not merely the balance of forces in the struggle between the colonizer and the colonized, but that altered the terrain of the struggle itself. And it's this terrain of struggle that I'm really interested in. So for Scott, similar to Assad, the focus of colonial power was not merely on the extraction of resources and the accumulation of capital for the benefit of the state, but the transformation of discursive spaces such that there was a systematic redefinition and transformation of the very terrain in which the life of the colonized was lived. This transformation meant that the actions of the colonized were not simply grounded in a terrain established by power, but that these actions were fundamentally fashioned and conceived in that terrain as well. As noted by multiple scholars of colonial India, one of the central areas in which the intrusion of colonial power was felt most acutely was the law. Beginning with the arrival of the East India Company in the 1600s through the period of formal British control, law was seen as a central mechanism through which order could be maintained and the objectives of colonial power could be actively realized. Key in this process would be both the marginalization and control over Islamic law. In place of the system established by the Mughals, the English over centuries established a legal terrain based on notions of centralization and standardization. Crucially for Islamic law, this had a number of effects. The most kind of well-known of the effects that scholars typically tend to talk about was kind of the limitation of Islamic law to personal status law. And that, of course, is kind of obviously a very important transformation. And coupled with that was the process of translating Islamic legal texts, oftentimes inaccurately. And these texts were taken kind of representative of Islamic law as a whole. And I think many people kind of familiar with South Asian colonial history are familiar with this kind of basic transformation. But I want to kind of take it a step forward and say the narrowing of Islamic law was also coupled with a number of other transformations. The first was the standardization of key areas of law through the process of codification. The second was the establishment of hierarchical judiciary based on a common law framework in which precedent was key. And the third was the integration and centralization of the executive, judicial, and legislative arms. The cumulative effect of these changes, right, the translations, and then these three other things that I'm talking about, that is what I refer to as the colonial legal terrain, because that encompasses both how the law is being translated, interpreted, adjudicated, debated, passed, like every single thing is happening within all of the different institutions that have taken different kind of parts and pieces of the Islamic legal interpretive process. And so the cumulative effect is the creation of this colonial legal terrain in which all legal matters were under the purview of the state. This effectively meant that in addition to kind of political sovereignty, the colonial state now also assumed legal sovereignty. And this becomes really very important because that is something that then traditional ulama want to respond directly to. Now, crucially, the legal sovereignty over law extended to Islamic law because it was ultimately the colonial state and colonial judges that were interpreting, applying, and adjudicating Islamic law. Even though they were doing it in this narrow realm, they still had kind of this control over it. And so it's this process of creating this legal terrain and subsuming Islamic law within it that creates this, what I call public contestation over Islamic law, in which the key kind of pivot point becomes the question of who has legal sovereignty, right? Is it the colonial state that's assuming legal sovereignty, or is it going to be kind of the traditional ulama, where this historically has been kind of their remit of power? And this is the tug of war that we begin to see. So instead of kind of focusing on, you know, the specific issues that are happening within courtrooms or specific kind of issues in the passage of law, there's this broader debate that's happening intellectually about who has legal sovereignty in the colonial period with two different stakeholders, essentially. So what I want to turn to now is looking at how the ulama responded to this encroachment on legal sovereignty. Now, for the ulama, because they could not realistically reverse the establishment of the colonial legal train, right, because it was so multifaceted, and the concomitant narrowing of Islamic law, at least to personal status law within the colonial framework, their efforts were directed at establishing the legal sovereignty of the Muslim community over Islamic law and challenging any colonial attempts to treat Islamic law as equivalent to other forms of law that they exercised control over. In demonstrating how the ulama argued for legal sovereignty in my book, I kind of go into, Deobandi, Brelvi, Ahl Hadith, Farangi Mahalli, like all the different kind of intellectual approaches that were percolating at the time. For the purposes of the conversation today, I'm just going to focus on a few Deobandi and Brelvi scholars just to kind of give us a sense of how this debate was playing out. And if people are interested, we can maybe get into it a bit more later. So once again, I want to say what my basic kind of findings are here is that even though the ulama from these different intellectual groups did not necessarily come to an agreement on how to define legal sovereignty, they all agreed that with the loss of political sovereignty, you could bifurcate political sovereignty from legal sovereignty. And that Muslims, despite accepting the loss of political sovereignty, could not, in the colonial context, also accept the loss of legal sovereignty. And you see this debate kind of playing out. Some of the scholars also are unwilling to accept the loss of political sovereignty. And then we have a bunch of kind of historical movements that obviously tried for various ways to overturn colonial power. But generally speaking, even those individuals that accepted the loss of political sovereignty, for them, the red line was the law. That you may have taken political control, but legal control has to remain with the Muslim community. So one of the earliest fatwas for this is the famous fatwa of Shah Abdulaziz, in which he discusses the loss of Muslim political sovereignty in his famous fatwa that characterizes India as Dar al-Harb. And crucially for him, the classification of India as Dar al-Harb enabled Muslims to engage in a variety of transactions that were otherwise impermissible within Dar al-Islam. So though he was willing to accept both the loss of political sovereignty and even the change in substantive Islamic legal rulings, he was adamant that Muslims in Dar al-Harb should appoint an independent hakim to oversee their legal affairs. And if you could not find an independent hakim, then you need to appoint some type of leader, which he refers to as a rais, who could assume responsibility of the basic legal needs of Muslims. And this individual should be collectively appointed. In his fatwa, he ultimately concedes then to political sovereignty, but he does not concede to the loss of legal sovereignty. So continued legal sovereignty for him becomes connected to the independence and integrity of the Muslim community, especially during a time of upheaval, and in the case of colonial India, during the time of occupation. And this basic bifurcation established by him in the early colonial period becomes a mainstay in later discussions, especially within the Deobandi school. So for example, we see one of the founders of the Deobandi Madrasa, Rashid Ahmad Gangohi, who was echoing this position of Shah Abdulaziz and argues that if you don't have a Shadari Qadi, then if two individuals agree to a matter amongst themselves, then the decision between two Muslims can be considered the equivalent to a judicial ruling, which is Hukm al-Qadi, which is quite remarkable in Islamic law, right? To say that two individuals, if you come to a conclusion, then that decision is the same kind of epistemological weight of a judicial decision, right? And so within the realm of Islamic law, this is almost kind of inconceivable to make this type of argument. Turning more directly to the issue of colonial encroachment, another leading Deobandi figure, Kifayatullah Dehlawi, argued that rulings issued by colonial judges pertaining to Islamic law, of course, have no legal validity. And even with the loss of political sovereignty, if Muslims agree to the appointment of the Qadi, that Qadi will not be considered a true Qadi, because the right to appoint one is only one that belongs to a political leader. So what Muslims should do is either appoint walis who can oversee their affairs in a more informal manner, or, and he goes as far as saying, and kind of introduces this argument, that Muslims should actually take judicial appointments within colonial courts, and that a Muslim appointed in a colonial court is actually a Shadari Qadi, not a colonial Qadi, and therefore Muslims who are going and getting a ruling despite being within the parameters of the court are still actually getting a Shadari ruling because it's coming from this Muslim judge. And so in the most prominent cases in his Fatawa collection, which is regarding absent husbands, he gives 5 different things that people can do. Sometimes it's traveling to another state, sometimes it's borrowing a Maliki opinion, but he also emphasizes that this is another route, that Muslims have this route to become Sharia qadis by just entering into the colonial judiciary. And for him, he kind of guards off that space and says, here's a little space of legal sovereignty that we're carving for Muslims, despite this apparatus overall being quite problematic. And what we end up seeing in even the later Deobandi fatwas is that the general options laid out by Mufti Kifayatullah were echoed by most of his contemporaries. Another famous Deobandi scholar, Maulana Ashraf Ali Thanwi, agreed with Mufti Kifayatullah that the best course of action would actually be for Muslims to be appointed as colonial officials, and then they could deal with the high volume of cases that Muslims need adjudicated. And so, though the discourse on legal sovereignty under colonial rule within the Deobandi school evolved over years, we see different scholars emphasizing different things. At the core of all of their articulations was the idea that we can concede on a lot of different things, but we cannot concede on this idea of legal sovereignty, that we have to maintain that as something that belongs to the Muslim community. And then we have these 5, 10 different ways that we're going to ensure that legal sovereignty is going to remain within the Muslim community. A slightly different but quite interesting approach is taken by the Brailvis, and I will just look at Ahmed Raza Khan here, the founder of the Brailvi school, who was born just 1 year prior to the rebellion of 1857, and therefore he spent the majority of his life really experiencing the full force of colonial rule. Before discussing his notion of legal sovereignty, he also kind of talks about this broader question of political sovereignty, and this question of whether India is classified as Dar al-Harb or Dar al-Islam. And what's quite interesting is that he starts this conversation by quoting a passage from Fatawa al-Amgiri, which states that for a territory to transition from Dar al-Harb to Dar al-Islam, there's only one condition, namely that the rules of the Sharia are widely enforced or propagated. And for the other way around, namely from something to go from Dar al-Islam to Dar al-Harb, there are 3 conditions which are outlined by Abu Hanifa, which were echoed, and many of these conditions were followed by the Deobandi colleagues. But of the 3 conditions, he said, the most important is that the laws of Muslims are no longer enforced. And so commenting upon this idea, he says that even if a single Islamic legal ruling is applied, the territory cannot accurately be transformed from Dar al-Islam to Dar al-Harb. His argument is essentially as follows. If a territory becomes Dar al-Islam due to the presence of the Sharia, then for the opposite to be the case, there should not be a single ruling of the Sharia remaining. And so despite there being 3 formal conditions for a territory to go from Dar al-Islam to Dar al-Harb, the most important for him is that some Shari'i ruling is still being enforced. And since in the time of India, he says, or since in his time of living in India, he says the rules of the Sharia were still enforced, India is Dar al-Islam. And so for him, political sovereignty has not completely been lost within the Muslim community, right? We've given some type of political power for sure, but there's still a sense in which he says we're living in Dar al-Islam. And so he has this really kind of, pithy line in which he says, the conclusion is that there's no doubt in the classification of Hindustan as Dar al-Islam, which is categorically different than what the Deobandis, of course, say. When he starts to think about legal sovereignty, this is addressed in a different kind of text that he has. He says we have to distinguish between what he calls Shari'i rule, wilaya shari'iyya, and customary rule, wilaya urfiyya. And on the status of how to think about kind of legal judgments in this time period, a person asks him, a Mustafti asks him whether Muslims are permitted to go to colonial courts, right? Similar to, these questions that were asked to Mufti Kifayatullah, and whether these rulings are actually binding upon Muslims. And before giving his answer, he establishes 6 different points. He says the primary duty of the Qadi is to secure the rights of the individual and prevent harm. It is not a requirement for the Qadi to be a mujtahid or pious individual historically because of the arguments of Fasad al-Zaman. He also says his third point is that though there's disagreement within the Hanafi madhab, some scholars allow qadis to give rulings on the basis of fatawa that are not necessarily their own. The fourth is that even qadis who accepted bribes were eventually allowed to continue to rule, and this kind of shows that there was kind of the bar, it wasn't as high always as we like to think. The fifth was that the appointment of qadis was always historically considered valid from a just ruler, an unjust ruler, even a non-Muslim ruler. And the sixth point that he makes before launching into his argument is that the appointment of a non-Muslim as a judge is valid, but their rulings are not binding on non-Muslims, right? This was a general Hanafi principle he provides from Ibn Abidin. And so he goes through these 6 points, and then he says, despite theoretically articulating kind of ideal qualifications for a qadi, namely that the qadi be a mujtahid, later scholars reneged on this requirement due to the absence of mujtahids. And so if they were willing, if scholars were historically willing to forego on the classification of or the requirement that a judge be a mujtahid, then when we are living in this very difficult time, should we not also forego the condition that the qadi actually be a Muslim? And so he makes this very provocative argument that the basic duty of the qadi is to secure the rights of the individual and prevent harm. And it is possible for a non-Muslim judge to fulfill this basic duty. And it's likely that he's aware of, the challenges, just like the Deobandi scholars were, of mounting cases that Muslims did not necessarily know how to get resolved. And so he eventually says that in this situation, it's Muslim laypersons who suffer the most. And there's no individual that's going to ensure that their rights are going to be legally safeguarded unless they go to these colonial courts. And so he ends with kind of his most forceful statement saying, in the situation of necessity or darura, the qadi being Muslim or non-Muslim is effectively the same. And on the surface, right, it seems like he's completely given up legal sovereignty, right? Because he's allowed for people to essentially go to non-Muslim scholars. In this case of darura, the requirement is not that the scholar be Muslim. But what's interesting is then when you read kind of further, he says that the reason that he's allowing for this to happen is because he's assuming that the British are not actually going to be interpreting Islamic law, but they're simply going to be applying it. So he's bifurcating legal sovereignty and the right to interpret and derive laws, which he says still remains the right of only Muslims, and the right to implement laws, which he says, because the British have undertaken during this time period, and we have a case of darura, we're accepting. And the end of his fatwa consists of, about a dozen scholars who agree with him, but within Barelvi circles, this fatwa did generate kind of a lot of contestation afterwards. Now, if we just kind of compare these two different ways of approaching the question of legal sovereignty, what's clear is that despite the fact that they have maybe a high bar versus a low bar, crucial for both the kind of the Deobandi scholars that I've mentioned and Ahmad Raza Khan is the fact that interpretation of Islamic law was the realm of Muslim scholars. And ideally, in the case of the Deobandis, adjudication was also the realm of Islamic scholars. So that's one important point to note. The other important point to note is that when reading the fatwas of all of these scholars, it's very clear that they are responding directly to the colonial legal terrain. They are not kind of just having this idea of legal sovereignty based on a kind of one of these questions where someone says qila wa qal, right? Where it's like we're going to make up an imaginary scenario and you answer to it. But these scholars are actually deeply embedded within what is happening to Islamic law within the colonial legal terrain. And this is something that, Muhammad Qasim Zaman has also pointed out, right? That these scholars didn't just retreat internally, but they were deeply involved in, religio-political activism, as he calls it. And I'm kind of looking specifically at what that looks like in relation to the law. But more broadly, this tug of war, right, in terms of who has legal sovereignty between, when the colonial government is trying to interpret Islamic law and when the ulama are actually saying, no, this is our kind of remit, resulted in a lot of public and pronounced debates. And we can see some of the most the most obvious cases when it comes to the passages of big laws. So for example, the Age of Consent Act in 1891 was a big moment in which the ulama really publicly engaged. The Child Marriage Restraint Act of 1929, the Shariat Application Act of 1937, the Dissolution of Marriages Act, and we can kind of go on and on and on about what was happening in each one of these cases. But in the background was this debate over legal sovereignty. And in the foreground were specific contestations around issues of personal status law. And what this did is it further entrenched within public discourse the problematic equivalency between Islamic law and personal status law, and the centrality of Islamic law to Muslim public identity and discourses. And it was these unintended consequences, right, resulting from these public legal contestations over Islamic law that narrowed the realm of public Muslim intellectual discourse. If the flashpoint was continuously Islamic law, then that kind of took up the oxygen, right? And we see this time and time again in a variety of different situations in both the colonial and in the post-colonial period. For some reason, my slides keep getting stuck, so I'm just going to try to catch up to them. But as I just mentioned right now, the consequences of this colonial contestation was this equivalency between Islamic law and personal status law, but the centrality of Islamic law to the Muslim public religious identity and the narrowing of Islamic intellectual discourses. And so with the time that I have left, and I know I don't have a lot, I just want to provide a few thoughts about Islamic legal sovereignties or decolonial Islamic legal sovereignties in the contemporary period. And maybe I'm connecting what was happening last term to this term, because I realize a lot of what I've said is actually more about the colonial period, but I think it's quite important to have it all as a background. As a starting point, I want to make it very clear that my remarks should not be taken as a criticism of Islamic law more broadly or a rejection of the place that it continues to play in Muslim societies. To the contrary, I believe that Islamic law can actually encourage the creation of dynamic discursive spaces in which discussions about normative practice can be had. And I also believe that Islamic law will continue and should continue to animate personal practice of religion. So I don't think it should be kind of tossed to the side. But I do think there are key areas of development that need to happen for Islamic intellectual discourses to start more meaningfully engaging with some of the changes that are happening in the contemporary context. So on the social level, the terrain, as I've mentioned before, which Islamic law currently occupies within the public intellectual discourse about religion, is to the detriment of other discourses, be they epistemology, philosophy, theology, history, politics, spirituality, and the list can kind of go on. And so I think a conscious effort must be made by Islamic legal scholars to both engage with these disciplines publicly and establish their value as part of the public intellectual discourses about religion. And I keep using this word public because I do think the ways in which we speak about religion publicly very much informs what discourses we think are normative or acceptable or, central to the Islamic intellectual tradition and which discourses aren't. I also think that it's important that these discussions need to adopt frameworks and language that's not necessarily dominated by legal discourse, right? So I often have students come to me during office hours and they'll ask me questions. They'll be like, is this halal or is it haram, or where does it fall on the spectrum? And I often respond to them and say, this isn't an Islamic legal question, right? And I think part of it is that we're always looking for fatwa. And I think that needs to be dialed back a little bit. On the level of discourse then about how we actually, Islamic legal scholars are speaking then, I think there has been narrowing of legal discourses as well because of an over-reliance on key institutions or key texts, preventing a more encompassing historical gaze. And this more encompassing historical gaze would not simply reveal the fact that oftentimes Islamic law is contested and fluid, but also that scholars actively engaged historically in their socio-political challenges, the socio-political challenges of their time, and they were very responsive to them. And I think it will also kind of help us realize that historically what made Islamic law dynamic and arguably what allowed for Islamic law to maintain a sense of vibrancy for such a long period of time was the fact that it was always debated. It was the fact that it wasn't necessarily kind of canonically set in a few legal texts. And so I think on the level of the discourse of Islamic law itself, I think there's a lot more room for robust methodological discussion and debate. And then finally on the state level, I don't want to discuss this too much because I feel like I'm just not qualified to really talk about anything when it comes with the state, but I do think there's still scope for discussing these questions about political legal sovereignty and the ways in which institutional framings of Islamic law in the contemporary state context continue to bear the markings of colonialism, and what impact that then has on Islamic judicial rulings that are coming out of state institutions. And so I know I haven't given kind of any answers about what decolonial Islamic legal sovereignties look like, but I would say kind of broadly for decolonial Islamic Islamic spiritualities generally to flourish, we have to really go back and think about what is the moral landscape, what is the intellectual landscape that we occupy, and what discourses are currently functioning most prominently within that moral landscape, and how do those discourses either kind of help other discourses flourish, or how do they prohibit other discourses from flourishing? And so I think Islamic law is a key intellectual discourse. I think historically it's always been a key intellectual discourse, but I think there's a way in which it's currently functioning. And again, I'm not trying to make an argument for the entire world, right? I'm really talking about the colonial kind of to post-colonial South Asian context, in which Islamic law might be functioning in a way that is not necessarily allowing for a full flourishing of other discourses. And I think there also can be meaningful ways in which there's convergence between Islamic law and other intellectual discourses that perhaps we can spend some time trying to explore. And I think that will leave us in a place where hopefully we can move the new kind of moral landscape in a more vibrant and dynamic direction. So I will leave my comments there.
Excellent. Thank you so much. That was a really very provocative presentation. So much to think about that you've given us. So, you know, I'm going to come at this as relatively well-read amateur. So my question has to do with, so I was just reading Miss Kawe's Tehzeeb al-Akhlaq. And there he says that the purpose of law is to create love in the community. And similarly, so Shahab Ahmed, when he's talking about the Sharia and what is Islam, he emphasizes, Sharia, the purpose of Sharia is welfare, the welfare of the community. So my question to you is there also simultaneously, I have a couple, so two parts to this question. So one of them is, how did, how in the historical transformation that you're charting, was there a transformation also in the understanding of what the purpose of law is? So, I mean, as I take it, I mean, part of the problem, of course, is that, people who, progressive people, for instance, in Pakistan, try to make it out as if Sufism, for instance, is antinomian. Yeah, so it's it's against the law. They're not concerned about the Sharia, which is, of course, completely absurd, because all of these Awliya Allah that we have over here, I can't imagine, Lal Shahbaz Qalandar or any of these people sitting around and smoking a pipe with marijuana in it or something like that. Yeah, so I can't imagine that they, I mean, there's no evidence to suggest that they lived non-Sharia. They were very, the Sharia itself is then just a part of the apparatus of self-perfection. Yeah, so so is there a change in that respect, in an understanding of what the ends of the Sharia, what is Sharia for? Yeah, is there a change in that? That's one question I had.
Yeah, I mean, I think that's a great question. I think, starting very early on, you have a discussion, 10th century of like, what is the purpose of Sharia, right? And I don't think that discussion ever really goes away. And I think different scholars respond to it in different ways. So early on, sometimes they see it was to facilitate ease for individuals. Other times it was maslaha, and then maslaha was defined Public welfare is defined in a varieties of ways. You have the maqasid debate, right? That it's supposed to uphold these 5 kind of important purposes. And so I don't think the colonial period takes that debate away. I think, if you move out of the fatwa collections, those conversations are continuing to happen, right? In many different books that are being published in the colonial period. So I don't want it to make it seem like the only thing that ulama are doing are writing the fatwas about responding to colonial power. There's actually a rich intellectual discourse that is taking place even during the colonial period. But the problem that I'm identifying is that of that rich intellectual discourse that is still textually being produced, what is publicly being articulated? Right. So it's great if you can talk about the Sharia in all of these different ways about cultivation of the self and self-perfection and those discourses continue. But unless those discourses percolate into the public sphere, then it's not really going to impact the Muslim imaginary or imagination, right? We're then going to start equating the Sharia with legal rulings. And so I think for me, it's not necessarily that those discourses didn't take place anymore. I think intellectually, there were still scholars who were writing about these issues. I think the bigger problem was that those conversations were not happening necessarily in the type of public contestations that I've identified in that period.
Okay, excellent. So the other question I had was in terms of the ulama themselves, these other discourses. So, even if you look at 19th century ulama, Shibli Nomani's teacher, I'm just giving this as an example. I can't remember his full name, but there were these 2 Chiryakoti brothers who were, very well, you probably know them better than I do. But they were, this anecdote he tells about one of the Maulana Chiryakoti in the morning, he knew the entire Diwan of Abu Nabbas by heart. And in the morning, he would recite as he was going about his routine. He would be singing, from the Diwan, yeah, which he had memorized entirely. It seems that the participation of the ulama themselves in all of these other, because so many of them wrote poetry, etc. Not only, so when we are talking about the narrowing of Sharia, are we also talking about a narrowing of the culture, the intellectual culture of the ulama?
Yeah, I mean, I would say I haven't read probably as widely as you have about the broader intellectual culture of the ulama in this period. Like, that's something that I want to do, but based on my cursory reading, I don't think it was that significantly narrowed, right? It depends on which areas in which you look, but I think there's still really interesting texts that are being produced. Like a lot of the scholars in which they have fatwa collections, they then have these very long diwans that they're writing, right? Poetry about all sorts of different issues, right? Oftentimes writing even texts on architecture, right? So there isn't necessarily this idea, I think we sometimes think that the ulama aren't necessarily engaging in issues except the law, but that wasn't necessarily the case. And I think the earlier period is especially, you have much more flourishing kind of 17th, 18th century. This is something that's been, I think, highlighted by Sher Ali in his recent work. It's also been highlighted by someone like Ahmed Dalal, right? That this period wasn't a period of intellectual stagnation by any stretch of the imagination. It's been depicted as a period of intellectual stagnation because of how Orientalist scholars kind of characterize it as this despotic kind of law-obsessed place. So I think that's one element. And the element that I'm trying to highlight is, what's happening publicly, right? And public discourses affect public perception, right? So you could have, these amazing things happening within the madrasas, but if the average individual is, not engaging with those, and for the average individual, they want to get their legal case handled about their missing husband or about their stolen property, right? For them, the issues primarily become legal. And so I think that is what remains or still ends up being a challenge today.
Thank you. Sajjad?
Yeah, I mean, in some ways that kind of raises this whole issue of, what happens to the courtly culture, right? So as long as the ulama were part of this courtly culture where of zarafat and of kind of adab and being engaged in philosophy and poetry and chess and discoursing with courtesans and all the sort of stuff that we hear about from the 18th, well, in Delhi in the 19th century. That's all well and good, but then once the court doesn't exist, in the colonial period, it starts to disappear, and certainly in the post-colonial period, it disappears. There's no demand for that, and so someone like Ashraf Ali Thanvi probably is one of the last of a kind, of someone who knows his Hafiz and his Maulana as well as he knows his Hanafi legal texts, and so then you get a context in which yes, you have fuqaha who are still being called upon to give these basic fatwas on everything from when is Eid going to be to should I donate an organ to should I vote in a particular election and so forth, but they really can't do much else. And then if they are then called on to become public theologians, because it seems that when you look across the Muslim world, not just in South Asia, but this kind of desire for public theology is very much there, but that space is only being filled by people who have a fiqhi training and not much else. That's unless you go beyond into the kind of the realm of tariqas and even, let's face it, into cults. That's a different kind of liminal space, which exists as much in the West as it does in Muslim majority places. But that then becomes kind of the issue, right? It becomes, if you are going to think decolonially about how you change ways of epistemology, maybe you try to repair and recover epistemologies which have been lost, a kind of a joint up curriculum of manqulat and maqbulat and adab and so forth. How do you actually do that? It's really difficult to see what that space is. There is no real existing Dars Nizami anywhere in the world. There's no desire really to revive it. And when people had discourse nowadays, whether it's in South Asia or elsewhere, about reinserting philosophy, say, into the training of ulama, so that the ulama can, who are legal scholars, can do a bit more. I sometimes feel that there was a very narrow conception of what philosophy is being promoted. So you have people talking about, teaching of modern logic and of the analytic tradition, which, I mean, the analytic tradition doesn't cohere very well with what was going on before as well. So it does become a case of, if you want to understand spirituality, what sort of training does one have to have for those people who can then at least guide people in that particular way. And then of course the other issue, of course, you have in the understanding of law nowadays. You mentioned maqasid. It seems that it's becoming a commonplace, particularly amongst those who Nauman refers to as the pade likhas, that law is primarily about ethics. It's not about rules, right? So as long as we stick to the ethics, as long as we're good people and we're good to each other, then it's all well and good. And I really wonder whether that's a massive simplification of what Islamic law traditionally has been, or whether that's even what most people expect. Is it just a simple thing? Okay, law is there to affect cultivation of character, but it seems to be much more than that.
I mean, I think there's so many points that you raise. I think law has definitely been watered down, because I think there is a way in which people want the law to somehow justify whatever it is that they've already decided that they want to do, right? So then it's much easier if we can invoke the maqasid, right? To say, oh, well, the Sharia is about life and reason and about family and honor. It's much easier for me to justify whatever my end goal is if I invoke the maqasid, as opposed to going through kind of the deep textual work that is needed to arrive at whether the solution is actually hermeneutically and epistemologically possible, right? And so I think part of it is a lot of the contemporary way of thinking about the law as simply ethics or love, I think can sometimes be, frankly, a bit lazy. And usually, there's some justification for, most of the time when I dig, I'll be like, oh, that's the legal ruling that like we wanted to employ this framework for. And so I think that ends up being part of the problem, right? Is that how do you make Islamic law kind of a dynamic tradition that can engage with contemporary problems, but also not just like water it down and make it into ethics, right? Just so it accords with our modern sensibilities. And I think this ties into the issue of training, that how do you really train people in the broad Islamic intellectual tradition? One of the things that stands out, at least in the South Asian context, is the fact that a lot of people can't access texts in Persian, right? That really does kind of intellectually limit us. And I think wherever you go in the Islamic world, there's kind of this emphasis on Arabic. And what was so interesting to me is, I was reading about why the Hidayah, when it was translated into English, it was translated into Persian first. And one of the arguments was that, well, a lot of the muftis they can't read Arabic. So if we just translate it into English, then they have a text that is in Arabic and a text that's in English, and neither of them they can read. So we need to translate the Hidayah into Persian because the muftis only understand Persian, right? Whereas now, if you look at the contemporary training, there's so much focus on Arabic language, but that Arabic language gives you access to one intellectual tradition, but then it also shuts you off from another one. And so I think part of it is also, we need broader training. We need, I think, there also needs to be given more time and even patronage to just publishing and publishing slowly, right? That I think sometimes there's so much of a focus on just answering contemporary questions, right? The last time I read a fatwa that was written by a living Muslim scholar that I was like blown away by, like you can think about it maybe. I can't actually really think about a fatwa that for me was really sophisticated and really engaging. Not to say that doesn't exist, but that's no longer the way in which we engage with Islamic law publicly. Whereas if I look even in the colonial period, I can think about multiple fatwas that are 30, 40, 50 pages that are really trying to take on an issue and be open about it and be deeply intellectually engaged about it, recalling text, thinking about the social context. And I think, when it comes to modern muftis and the volume of text, if you have places like Egypt which have fatwa robots, right, it really devalues what that intellectual discourse should be. And I think until we start valuing it more and understanding the work and time that it takes, and not just making Islamic, like the most interesting stuff they say ends up being about Islamic finance, right? Like that's where you end up having the most lengthy fatwas. But again, what does that tell you about what scholars are giving their energies to, right? That we can have 50 fatwas about Islamic finance and this mortgage and this credit card and debt financing, and the amount of legal scholars that were discussing cryptocurrency, thinking, why aren't you discussing other issues with the same degree of gusto and enthusiasm? And well, so I think
the simple answer is it's money, because people on compliance boards get paid retainers. I mean, it's really as simple as that. You don't get paid a retainer to give a fatwa on a bioethical issue or on an issue relating to gender rights or anything like that. But you do when it comes to financial instruments.
But that's why that all contributes to why the Islamic legal discourse or the Islamic legal space looks the way it looks like, right? There's an overuse of fatwas sometimes. These fatwas, when it comes to really important issues of bioethics, family, gender, are oftentimes not well thought out, relying simply on old fatwas. And then when it comes to issues of finance and money, then all of a sudden you have these really lengthy fatwas that are published, and people are trying to engage in a really sophisticated way. And I think that in itself reveals a big problem about how we're actually thinking about what the purpose of the law is, right? If we go back to the original question, that if we're dedicating all our time to figure out questions about Bitcoin, then is the purpose of law just to facilitate the accumulation of wealth. In some way, that's what we're saying.
Or yeah, and that directly fits to kind of a rather cynical approach to looking at law as merely the control and governmentality of the public order, right? So as long as you can kind of ensure that and the control of bodies who are within that public space, then that's absolutely fine. I mean, perhaps one of the issues about this kind of public discourse of how a fatwa works is the way in which publics have developed and shifted, right? So, even if we consider some of these fatwas from the late 19th, mid 19th, even early 20th century to be public, those publics were much more limited and they were quite distinct. So, it's very different from, someone giving a discursive fatwa which people might read to, say, someone giving a fatwa on TV, right, or on online, where perhaps there isn't really going to be much space. There isn't going to be much back and forth on TV or online, because you just people just want, in a sense, the answer. They don't necessarily want that kind of elaborate performance. Whereas in a discursive piece, in a risala, it's a different kind of function of what's being presented for that position. So I think it's partly that question of what sort of performance is there in the issuing of fatwa. And I wonder whether there is actually the appetite nowadays to revive that sort of thing, but just to understand that, as you said, allow for slow research and the slow production of text. But, will anyone actually read that at the end? The only long fatwas I can think of in recent times, apart from the financial, are of course on the other big issue of the modern post 9/11 world, which is on violence, right? So you've got these huge fatwas on jihad, etc. I don't think anyone ever reads the whole of those. I mean, whether it's what's his name, Tahir al-Qadiri, or whether it's Yusuf Qaradawi, etc. But it's the fact that they exist as certain kinds of performance pieces, which are interesting. Again, for me, it would be really interesting to see if anyone would actually be bothered to do something like that on the whole question of gender and what constitutes, biological sex or not. How do you deal with questions of transgender rights, which is becoming a huge issue. There are plenty of pre-modern kind of fatwas on that, which are really interesting, but no one's really picked up on that in the contemporary period at all. And certainly for those of us who live in, kind of the Western metropolitan academe, those would actually be quite interesting and useful for the debates that we're having. But I'm not sure where the appetite is.
I mean, I think there's appetite for certain questions that are, like, I think there is a lot of appetite if somebody writes a fatwa on that, but I think for a lot of people, there is that big elephant in the room, which is power. Right. And so a lot of the individuals who are sitting on television and they're issuing these fatwas, they want people to call in and ask the simple questions, and they give the simple answers, and they don't want to wade into the, it's all good and well if you're justifying a new financial transaction, but if all of a sudden you're now alienating people with your fatwa, then that's not necessarily going to be good for your own bottom line. And so I think there's the thing of a lot of individuals who are perpetuating a fast fatwa culture want to remain in power. And I think that's one side of the coin. I think the other side of the coin is that, we have to address the fact that modern Muslims are oftentimes very insecure about basic functioning, right? And they feel that they need a fatwa for something. So when I have students coming to me and asking me questions, and I'm saying you don't need a fatwa for that, right? It reveals kind of a modern religious anxiety over, am I doing the right thing? And I need someone to tell me that I'm doing the right thing. And so therefore I'm going to start asking for fatwas on things which maybe historically were not even the realm of fatwa giving. And so I think it's this combination of, modern religious anxieties, which is not just in the Muslim community. Like sociologists of religion have been pointing towards kind of contemporary religious anxieties for a very long time, right? So Muslims are just now another case study, I think, in this. And then the other side is this idea of authority, right? And I think if you look at all of the conversations historically about why Muslim scholars said you shouldn't get paid by the state, right, or should maintain this independence, it was always this sense that once you start getting paid by the state, once you want that power, then you want to keep that power. And so I think there's a lot of there's a lot more than just kind of there's a lot more contributing to what we're seeing than simply just a lack of engagement intellectually with Islamic law as a more complicated legal tradition.
Sajjad, may I come in?
Yes, of course. Go ahead.
Since we've been talking about the ulama, I thought we should also say about what happened to the general intellectual culture in other ways also, which the most obvious sorts of things really, but just to register that, of course, the entire intellectual domain was utterly wrecked. Yeah, so really from the second half or the last quarter of the 19th century through the 20th, this entirely new kinds of educational institutions came up, and new forms of education, and nothing was happening really in the rest of and this continues to this day. Yeah, so most academics, I was just saying to somebody the other day, in fact, all of my science colleagues are observant, and on the other hand, everybody in the humanities and the social sciences is like, if you engage in all of this, it's as if you're there's something wrong with you. Yeah, so that's a big problem in terms of decolonizing or taking back the space. Yeah, taking back this intellectual space is there are no takers for that either. Yeah, so on the one hand, the ulama have been utterly corrupted by this modern obsession with power. Yeah, and because these national identities are so closely tied, as you're pointing out, from the colonial period, really, legal identity and national identity are so closely tied in. Yeah, this legal sovereignty that you're talking about and national sovereignty in a place like Pakistan have become deeply intertwined. Yeah, in a way that, and on the other hand, the quote unquote intelligentsia has completely abandoned the entire intellectual space to these people in terms of anybody who can, speak with any kind of authority, about the tradition, about the inheritance.
Yeah, I remember when I decided to do my PhD in Islamic studies, my family that was in South Asia was like, but we stopped doing Islamiyat at like 7th grade here. Like, what does a PhD in Islamic studies even mean or look like, right? And I think that is part of the challenge. And I sometimes have this conversation with friends, and it is, for me, sometimes it is sad that some of the most exciting work, contemporary work produced in Islamic studies is often coming out of Muslim scholars who are writing within the confines of the academy, right? And it has its own limitations, right? But it also opens up a space sometimes for people to engage in interesting ways. And so I think religion doesn't have that, to study religion, to be engaged with it. It's almost like that in and of itself doesn't have any social value. And I think that ends up being a huge problem, because if we're talking about kind of decolonial Islamic spiritualities, we're fundamentally saying that we need to put more effort, both on the intellectual level, but also on the social level, for people to invest time and energy into these conversations, right? Regardless of how we want to characterize the, contemporary Muslim publics, we're saying that those publics are important. But if fundamentally we see an intellectual narrowing of what conversations are taking place, and people actually don't value those discourses, right? They don't want to spend time and attention to think about those, then it makes it very hard for those discourses to flourish. And I think for me, that is one of the biggest challenges, right? Like, how do you move to a place where epistemologically people are no longer kind of thinking in these colonial frameworks, and where people are actually giving social value to religious discourses, thereby also elevating them, right? So it's not just I'm turning to Islamic law because I need to know how many witnesses I need for my wedding, or when I need to call the Molvi to come do my nikah, but I'm actually thinking about it in a much more sophisticated way, and I can think about not just Islamic law, but all of these other discourses as meaningfully contributing and adding value to whatever contemporary questions I'm grappling with. I think there's a lot of work to be done before we get to that place.
Right. So you're absolutely right. But what I was also indicating is, so in a bookstore in Karachi, if you go to a Liberty bookstore, and you go to the philosophy section, all of the books in the philosophy section will be Western philosophy. In order to look at the Islamic philosophy books that they do have, of course, they have a terrible selection anyway. There's, it's become trashier and trashier over the years. But what they do have will be in the religious section. So if you're one book by Mullah Sadra, you will find, which has been published by the Sohail publishers, Sawane, that will be in the religion section. So you won't, and that's because, the people who are interested in philosophy, will go and read whatever, Bertrand Russell, or maybe, sometimes there's a surprise book sitting in Liberty bookstore. So there was Being and Time by Heidegger was sitting there, but, this very, the way it's divided is bizarre, so why shouldn't Ibn Sina be sitting there? I mean, these are very, so I think there's, as of course Sajjad has written a book on Mullah Sadra, but it's not just Mullah Sadra, there's so many other, I mean, Ibn Sina, etc., all of these, there's very, very rich ontologies, actually, ontologies that are, metaphysics, that's really, really important, that has lots to say about contemporary philosophical issues, but they're not interested in that. That might, as if these particular texts, because they're religious, they're put in, so I think that's a big part of the problem. It's not just that, they're not interested in religion, which is bizarre anyway, because what is religion? It's like you throw out centuries of human experience, large domains of human experience in the name of some bizarre category, this religion. So yes, of course.
What's in the law section? Just out of curiosity, have you looked at the law section? What's there?
No, there's no law section.
Oh, there's no law section.
Right.
Sometimes just seeing what's in the, sometimes in the law section is when you have the interesting things, maybe about the hudud or something like that. So I thought maybe they snuck something in.
The Liberty bookstore is not that extensive. There's, and I mean, the sheer poverty of intellectual discourse, actually, Karachi really typifies it. There's hardly any good bookstores. I mean, well, there aren't any, actually, frankly. There are better bookstores in smaller cities in Pakistan, like Quetta or Peshawar, even, than there are in Karachi, because they're just obsessed with money.
Yeah, I mean, I think, when I've gone to, bookstores in America, one of the things that's interesting is you will find in the law section sometimes books on comparative law, or like, canon law, but you won't find books in Islamic law, right? And the Islam section, similarly in American bookstores, is woefully thin, and the religion section will, maybe have one or two books on Islam, and it tends to be then Rumi, with, a poor translation by Coleman Barks. And so I think, you also have the same, you have a problem happening, right, in a different context, but the same idea of narrowing of intellectual discourses, right? And I think it goes towards shaping a certain public understanding of Islam, whether that public understanding is being shaped in Karachi or whether that public understanding is being shaped in America, right? So in America, it's being shaped by, Ayaan Hirsi Ali and Coleman Barks, and not to say that they're the same, right? But it's, it's a certain flattening of intellectually what Islam has to offer. And I think that's the same case that you have in the Muslim world, which is quite unfortunate to hear it's echoed there as well.
Mm. Although it must be said, it's not as if, other societies are doing much better. I mean, we live in a particularly intellectually impoverished age. Yeah.
I mean, it's kind of weird because, we say that, but then we also have people watch this, right? They watch some of the other kind of rather interesting conversations we've had with people. Watch and listen to all sorts of very sophisticated podcasts. So there is, I think, a desire then. But when we're talking about what is reparative, before you can embrace what is reparative, you have to at least be aware of the fact that something is broken or damaged. And I mean, the reason why I think your project, and I'm looking forward to seeing the book, and I'm also aware of Junaid Qadri's book, which came out recently, and Muhammad Qasim Zaman and Shirley and all. I mean, what's useful precisely about all these works is that they give you a sense of the epistemicide and what is damaged. And unfortunately, Nauman, when you're speaking to people in Karachi or maybe even in Delhi, etc., a lot of people just don't necessarily have that sense of anything being damaged, which needs to be repaired. And I think that's precisely the issue. So whether it's the classic case of saying, well, look, we haven't got time for this because our basic survival needs are so great that we don't do this, or to say that, well, how is this beneficial to me? Because it's not the thing that's going to get me the job and help me in the startup in Hyderabad or whatever, or end up getting me that job in Silicon Valley. I can have my own business. I mean, that's just not. It doesn't register as a primary concern. So unless you get people to actually recognize that there is something which is damaged, and that there might actually be something of value, in a Fazl Haq Khairabadi or in a Ashraf Ali Thanvi for that matter, there isn't going to be that turn. It'll either be survival or it'll be like the pursuit of the dollar.
Well, I mean, the thing is, even those people, so look what's happening, yeah? Even those people who think that, who recognize that the world is now so damaged that they're going to have to escape to another planet, right? So they recognize that it's damaged, that it's very, very damaged. In fact, it's probably not salvageable. It's headed towards total catastrophe. They know this, but they think that they can escape to another planet. Yeah. So that's a big part of the problem. Is don't look up, right?
Someone one of my students was telling me, like, you need to write fatwas about space travel, and I was like, yes, that needs to be at the forefront of what Muslim scholars are doing. Let's start writing about which direction to pray on Mars. But I think, just on a personal note, and I said this in the beginning, that this project was very personal to me in a way that my previous project wasn't personal to me. And I think, part of when I came into Islamic studies, I was focusing on the pre-colonial tradition. I was focusing on law, and I was focusing on political thought. And for me, it was just intellectually really interesting to go through that entire process. But I actually realized when I left graduate school, I did an entire degree and I never took one class in South Asian history. And I think for me, that in itself was problematic, that people are now talking about what does it mean to decolonize the curriculum, right? What does it mean to have a more diversity of history courses and courses on colonialism at the undergraduate level? And it was only maybe 4 or 5 years ago that I was really thinking, I was like, did I ever take a course in South Asian history? Is everything that I have simply what I've inherited from my parents and conversations and in living rooms about, Pakistani and Indian politics. And so I think there's a way in which there's a conversation that we have to have specifically within the realm of kind of Islam and Islamic studies and Islamic intellectual discourses. But I think there's also a broader conversation that we have to have even about how the humanities and how degrees are structured in Western academia, because there is a specific way in which certain histories are privileged. And there is, you come in and you have to take 4 courses on Western intellectual history. Well, what about all the other histories that are out there? And so, I think people are seeing with Black Lives Matter and the 1619 Project and this idea of thinking about history differently. And I think Muslims also have to contribute not just to these Islamic intellectual discourses and a revival of Islamic intellectual discourses, but how do these discourses fit more broadly, right, within how we think intellectually about the world as a whole? Because we also don't want it to become where Islam is just like, well, this is something that Muslims are going to study if they go and do their PhDs in Islamic studies, or if they get really interested in it and decide to pursue something. But I think there's something to be said about how we still are thinking about world history and intellectual history in universities and at the high school level that actually really is to the fundamental disservice of Muslims and others from various backgrounds. And so I think we have to keep that narrow focus on, Islam and Islamic intellectual discourses. But I think we also can't lose sight of the fact that there is a bigger conversation that Muslim scholars also need to be tapping into and need to be actively engaged in. Because if I can go through 25 years of American education and never take a course on South Asian history, despite the fact that you think about the population size globally, or never took a course on imperialism or colonialism, that means we've got fundamentally problematic intellectual structures, not just in the Muslim world, but also in the Western world, that need to be addressed.
Absolutely. Sajjad, we promised Sohaira we would keep
Yeah,
it.
I'm aware of that, and we've gone over that time, so we should probably wrap things up. Unfortunately, I don't seem to have seen any questions which have come in from the Facebook stream, which is a shame, but I guess if there are any questions which come in afterwards, we can try and pick them up. But thank you for that really stimulating presentation, and I'm very much looking forward to seeing the book and seeing Gunan at some point. And thank you for everyone who's tuned in. I think next week we've got Noah Solomon, if I remember correctly. I can't remember the title, but we'll remind people. So please do join us again. In fact, because of a few shifts, I think we've got 3 in a row, or including today, we've got 4 weeks in a row, which was not originally the plan, but yeah, it'll be a busy few weeks, but so looking forward to continuing those conversations. So thank you for watching, and thank you once again, Sohaira.
Thank you, Sohaira.
Thank you both.
Khuda Hafiz.
Khuda Hafiz.